Hello friends, we are back with the latest video on Doctrine of Frustration under the Indian Contract Act 1872. So in this video we will see what is Doctrine of Frustration and what are the important case laws be associated with the doctrine. Okay, so let's start. So have you ever entered into a contract? If yes, then you might be aware that a contract creates mutual rights and obligation between the parties wherein they are bound to perform their duties, right? What if a party fails to perform its duties? In that case, this surely amounts to the breach of contract and the party will be liable. What would happen if a particular circumstance renders it impossible for the parties to perform their duties? Such situations are usually out of control of the parties, and when such events occur, the contracts are said to be frustrated. So, starting with the introduction part, the term frustration is being used to deal with unsuccessful transactions which could not be completed due to any reason. In law of contracts, the doctrine of frustration has emerged as one of the most common issues which have arrived to deal with the failed contracts. So इसका एक एग्जाम्पल लेते हैं. For example, A and B get into a contract to sell a cow for the purpose of slaughtering, or next day national government introduced a law saying that selling of cows for slaughter purposes will become illegal. अब इस केस में क्या हुआ कि the contract between A and B would become a frustrated contract. क्यों? क्योंकि परफॉर्मेंस ही इम्पॉसिबल हो गई. जो ऑब्जेक्टिव था slaughtering of cow was declared illegal by the government of India on very next day, जिसकी वजह से इसका जो ऑब्जेक्टिव था वो खत्म हो गया. Evolution of doctrine of frustration. The doctrine of frustration is an English common law doctrine which has been incorporated under the section 56 of the Indian Contract Act 1872 and hence has been given the statutory recognition. According to this doctrine, if the performance of a contract becomes impossible due to supervening impossibility, then the promisor is excused from the performance of contract, जो कि हमने अभी पिछले एग्जाम्पल में देखा भी था. Section 56 is based on the maxim "less non quasit et impossibilia," which means that the law will not compel a man to do what he cannot possibly perform. Now, let's move on to the next slide. So, here comes the landmark case for the doctrine of frustration. Satyabrata Ghose versus Mugneeram Bangur. तो पहले केस को एक बार लेमन लैंग्वेज में समझ लेते हैं, उसके बाद स्लाइड का कंटेंट एक बार चेक करते हैं. Mugneeram Bangur and Company was the defendant in this case. His company owned a very vast area of land in Calcutta. In order to develop the land and make it fit for the residential purposes, the company decided to divide the large tract of land into different small plots and sell them. The company started working as per the plan and made certain agreements for the sale of plots with various purchasers. It also asked for some money deposits from the buyers and received the same. The company, on the other hand, took the responsibility of providing all the necessities for the residential purposes, be it the construction of roads, drainage system, or any other essential. For the completion of construction, all the essentials, no time limit was specified in the agreement. अब हमने देखा है कोई भी agreement है उसमें time limit is essence of the contract, but जो मुगनीराम बांगर ने कॉन्ट्रैक्ट किया अपने बायर्स के साथ उसमें कोई टाइम लिमिट नहीं दी कि कब तक कंस्ट्रक्शन वो कंप्लीट करके देगा. It was decided that after all such construction is done, the company, after receiving the complete payment from the buyers of the plot, will provide the land to respective buyers. अब आते हैं सत्यव्रता घोष, the plaintiff of the case, was also interested in purchasing the plot of land and therefore entered into an agreement with Mugneeram Bangur. company. The plaintiff gave the advance money deposit of rupees 101 in August 1941. Following in time, as war conditions were frequent at those times, the government in 1943 decided to take over the land and make use of it for some military purposes, as a result of which Mugneeram Bangur and Company decided to treat the contract cancelled due to the impossibility of further construction and sale, and they conveyed the same to the buyers. उसके बाद मुगनीराम बांगर ने buyers को दो ऑप्शन दिए कि फर्स्ट वन टू टेक बैक द अर्नेस्ट मनी, ठीक है, सेकंड वन कि is to buy the entire amount to the company, and once the war is terminated the company would continue its construction work on the land. फर्स्ट कि या तो पैसा जो डिपॉजिट किया इनिशियली बायर्स ने वो वापस ले लो, सेकंड कि वो पैसा वापस ना लो, वो डिपॉजिट ही रहने दो, और एक बार वॉर खत्म हो जाएगा तो मुगनीराम बांगर वापस से कंस्ट्रक्शन स्टार्ट करेगा और कंप्लीट करके लैंड एरिया वो बायर्स को दे देगा. Satyabrata Ghose denied both the available options and decided to file a suit on 18th January 1946 against Mugneeram Bangur and Company, saying that it was bound to the terms of contract in January 1946. Now, what the court has said, the court has held that doctrine in India is also applicable in cases where the contract cannot be performed due to the reasons or factors beyond the control of parties, which means that it is applicable only in the cases of subsequent impossibility. So, doctrine of frustration सिर्फ उन्हीं cases में apply होता है जहां पे contract की performance बिल्कुल ही impossible हो जाती है. So, इसमें issues क्या क्या आए? First one, did the contract of sale of land become frustrated after the given circumstances under the section 56 of the Indian Contract Act, which we will see in the next slide? Second, does the English law of frustration apply in India? So, now moving on the next slide. So let us see what was the judgment in this case of Satyabrata Ghosh versus Mugneeram Bangur. The Supreme Court of India held that although the government took back the land, but the impossibility of performance cannot apply in this case. Q. Point number one. The work did not start when the land was demanded by the defense of India. So, जब वॉर का टाइम आया और इंडियन गवर्नमेंट ने वो लैंड वापस डिमांड किया, तब तक मुगनीराम बांगर एंड कंपनी ने उस पे कोई भी काम स्टार्ट ही नहीं किया था. The plea of the defendant is just as the situations would give rise to undecided detainment in the contract's completion, and thus the impossibility shall apply. Second, however, there was no mention of a specified time limit in the contract, and demand was only short term. Thus, it concluded that there wasn't any unspecific slowdown. So, जो कॉन्ट्रैक्ट मुगनीराम बांगर एंड कंपनी अपने बायर्स के साथ कर रही थी उसमें उन्होंने कोई टाइम लिमिट नहीं दी कि कब तक वो प्लॉट्स पे कंस्ट्रक्शन कंप्लीट करके बायर्स को वापस करेगी, और जो गवर्नमेंट ने डिमांड की थी वो सिर्फ शॉर्ट टर्म के लिए थी. मतलब प्लॉट्स की डिमांड, गवर्नमेंट ने जमीन की डिमांड सिर्फ और सिर्फ वॉर टाइम के लिए की थी, right? So, thus it concluded that there wasn't any unspecific slowdown. Third one, the provision of Indian Contract Act, Section 56, stated that whenever a person while signing the contract has appropriate close attention which the other party didn't know about, then the party must compensate for the loss incurred by the other party. So, अब सेक्शन 56 सेज दैट अब जो साइन हुआ कॉन्ट्रैक्ट उसमें सारे डिस्क्लोजर्स देने चाहिए. अब इसमें मेन डिस्क्लोजर विच इज द एसेंस ऑफ द कॉन्ट्रैक्ट एक्ट एज वेल, विच इज टाइम लिमिट कि कब वो कॉन्ट्रैक्ट कंप्लीट होगा, जो कि मिसिंग था. उस केस में प्लान उस केस में द पार्टी इज सपोज टू कॉम्पनसेट द अदर पार्टी for the loss. Therefore, the case was decided in favor of the plaintiff Satyabrata Ghose. So, Satyabrata Ghose won the case against Mugneeram Bangur. Now let's move on to the next slide. What are the grounds for doctrine of frustration? First one, impossibility of performance. The doctrine is triggered when performance becomes impossible. This does not necessarily imply physical impossibility, but can include situation where performance becomes impracticable and the very foundation of the contract is disrupted, right? Second one, destruction of subject matter. अगर कॉन्ट्रैक्ट से एसोसिएटेड सब्जेक्ट मैटर ही डिस्ट्रॉय हो जाता है तो फिर हम कॉन्ट्रैक्ट को परफॉर्मेंस ही नहीं कर पाएंगे एंड द कॉन्ट्रैक्ट विल बिकम इम्पॉसिबल और फ्रस्ट्रेटेड. सेकेंड थर्ड वन, डेथ और इनकैपेसिटी ऑफ द पार्टी. अब जो पार्टीज आपस में कॉन्ट्रैक्ट कर रही थी उनमें से किसी एक पार्टी की डेथ हो जाती है, देन द परफॉर्मेंस विल बिकम इम्पॉसिबल, and that will also stand as a ground for doctrine of frustration. Fourth one, frustration by legal or government intervention. If a law is enacted after the contract's formation, that makes performance impossible. जो हमने फर्स्ट एग्जाम्पल में देखा था in the first slide for the slaughtering of cow, right? If a law is enacted after the contract's formation that makes the performance impossible, the contract becomes void. Fifth one, frustration due to change of circumstances. This occurs when there is no physical impossibility, but a change in circumstance undermines the contract's primary purpose. इस केस में भी हम कॉन्ट्रैक्ट को एक्सरसाइज नहीं कर पाएंगे. सिक्स वन इज द आउटब्रेक ऑफ वॉर विच कैन मेक द कॉन्ट्रैक्ट परफॉर्मेंस इम्पॉसिबल, राइट? So these were the grounds of the for exercising the doctrine of frustration. So now we can conclude that the doctrine codified in section 56 provides a legal framework for addressing changed circumstances that challenge the sanctity of the contract. It serves as a mechanism to ensure fairness and prevent parties from being forced to compensate for actions beyond their control. As we have explored in this article, the doctrine of frustration has evolved over time and continues to play a vital role in the Indian Contract Act. It also enables courts to apply a balanced approach in cases where contracts become impossible to fulfill. So that was it for the doctrine of frustration. We will be back with our new videos on Indian Contract Act. So for the time being आप इस वीडियो को प्लीज लाइक और शेयर करिए और मेरे चैनल को सब्सक्राइब कर लीजिए क्योंकि इस पे रेगुलर बेसिस पे कुछ ना कुछ मैं वीडियोस अपलोड करूंगी, तो आप लोगों को अपडेट्स मिलता रहेगा. आपके स्क्रीन पे राइट हैंड साइड पे एक बेल आइकन होगा, उसको प्रेस करके प्लीज आप मेरा चैनल सब्सक्राइब कर लीजिए एंड वीडियोस को लाइक और शेयर करते रहिए. थैंक यू सो मच.